Certainly.
This is a case involving a suspension of a bonding company in Hickman County, specifically for violation of 4011 125 and their local rules. We specifically find a problem with a sentence with regard to a source hearing. Rule 12-2 of their local rules states in part, any bonding entity to write such a bond shall provide notice to the court and the district attorney general. We find that that is in contention with 4011 126.5, which prohibits participating in the capacity of an attorney at a trial or hearing of one on whose bond the person is a surety. We all know what source hearings are, to provide proof to the district attorney that the funds are legal. We find a problem that the bonding entity is then going and providing proof to the state that these funds are legal. They are not an attorney, they do not know the background of a case, and we feel that that is acting as an attorney. In this matter here, our bonding agent, through the commencement of the district since 2022, has gone through the court clerk and has asked, hey, am I allowed to write this bond? That has been the accepted procedure up until this point in time, because he did not feel he was able to contact the district attorney because that would be acting as an attorney for the defendant. In this matter here, there was testimony that he did do that procedure that has been accepted in the past, and the court clerk said, yes, you are able to write it. The state then filed a petition asking to suspend the company because he did not give permission. Another issue here is that the district attorney should have recused himself, because in his opening statements, he said that district attorney self received notification from the court clerk. He is testifying to proof in this matter in his opening statement. It is shown in the record that I objected to it because he is essentially testifying. I asked later on if I could call him as a witness, and I was denied. And the trial court eventually took the district attorney's statements that notice had not been given and suspended the company. And so we would argue that the court should not have been allowed to take statements from the district attorney, and that they should not have been allowed to call the bonding agent because notice had not been given. Further, when the court suspended the bonding company for a period of 30 days, they made it a condition of probation that all bonds, including general sessions bonds, had to be approved by the circuit court judge. We feel that the circuit court judge did not have authority or jurisdiction to approve general sessions bonds. So this was not just bonds that started off in general sessions court. It's people who have been arrested off the street and a magistrate had been given. So he wanted to have authority over everything, and we contend that he did not have authority.
Had the case gone through the grand jury by the time the circuit judge got involved?
He has specifically said in the record before that would even happen. So essentially, if somebody was arrested off the street and the magistrate gave them a $105,000 bond, he would have to approve of the company making that bond. So he would be going over the general sessions judge head. So usually in that sort of matter, we would go in front of the general sessions judge. He wanted approval in that matter as circuit court judge, and we contend he did not have jurisdiction over that as well.
It seems that the case law governing bail bonding rules has given the trial court quite a bit of inherent power to oversee these things. How do you argue against what is established case law that gives the trial court the authority to do that, even over the general sessions judge?
Which specifically over the about of bonds, correct? Okay.
Yes.
So I would argue that if a case is pending in general sessions court, is it also then pending in circuit court? With regards to just the bonding matter, where would the source hearing be held? Would it be held in general sessions court, or would it be held in circuit court? And are we then bypassing the grand jury? My philosophy is if it's in general sessions, it needs to be heard by the general sessions judge, who would then have the preliminary hearing and be able to rule on everything specifically. Or are we then going to the circuit court judge and him hearing the preliminary hearing and the bond hearing? Because usually the facts of source hearings and things of that nature are kind of intertwined. For example, human trafficking, things like that, drug cases as well. Usually somebody is charged with a drug offense, and that's why they have a source hearing. things of that nature. You're intertwining them both, but he's overstepping for one part of it, but then he would also hear another part. And let's say the grand jury, no true billed it. He's essentially bypassing that as well.
But the case law seems to state that that's the inherent authority of the trial court. You agree with me on that?
I do agree with you, Judd.
And there's nowhere in the case law that says General Sessions judge has any authority over bail bond rules, correct?
Correct. They don't have authority over it, but they do rule in bail bond matters.
Certainly, they set bonds and lower bonds or raise bonds, correct?
Correct, and
But
they
as
also
far
give
as
relief.
what I think it's the Supreme Court rule gives the trial courts the authority to oversee bail bonding rules. Isn't that correct?
That is correct. But when does bail bonding rules conflict with a defendant's right in a criminal case? That is where I feel like we're kind of intersecting here, and it's kind of overstepping. Of course, I agree trial court can, make their own rules as long as it's not in violation with statutes or anything else like that. But we're getting into violating a defendant's right, getting into violating a General Sessions judge authority. We have a General Sessions judge in court for a reason, and they are before a grand jury for a reason. We're kind of overstepping that where, the General Sessions judge should be the one to approve of it, not the trial court in this matter. If there are no further questions.
Wait just a second. So you raised an issue about the bonding company could not contact or provide notice to the district attorney. Well, the notice, not only is the notice required, but also a hearing is required. And so the bonding company is going to have to hire an attorney. Why can't that attorney just provide notice? Here's the hearing date.
That is, so essentially, the bonding company is choosing a defendant's attorney at that point in time. So with these small counties, there's only court once a month.
That's the bonding company's attorney. They're the ones that are trying to make the bond.
Yes, but a hearing is not always required for a source hearing. In the note in their local rules, they say it's required, but in past accepted procedures by the district attorney, he's waived his right to a hearing. And that has said, I'm fine with the bond being made and move on, and that's through text messages with the court clerk. And if I had been able to have the district attorney testify, that would have been shown in the record, because not every $100,000 bond has had a source hearing in that district. So unfortunately, because the court ruled that I could not ask the district attorney to be cross-examined, I could not get that in, which led to another issue that, the district attorney should have been recused in this matter because he was representing the state and himself as well. If there are no further questions, I'd like to reserve my time. Thanks.
All right, thank you.
Good morning, Your Honor. May it please the court. Joshua Minchin on behalf of the state of Tennessee. I'm going to jump right into the arguments, starting with whether the local rule 12-2 violates Tennessee Code Annotated 4011-126, subsection 5. The state's frontline argument here is that the language of both the statute and the local rule is clear and unambiguous, and there is simply no conflict between them. And I think the best way to tease this out is by looking at the relevant language of the local rule as well as the statute. So in relevant part, the local rule provides any bonding entity desiring to write such a bond shall, and such a bond here is of $100,000 or more, shall provide notice to the court and the district attorney general, whereupon a hearing will be set by the court. So this is really nothing more than a notice requirement. But if we look at the statute particularly, it states that a bonding agent may not participate in the capacity of an attorney at a trial or hearing of one on whose bond the person is a surety. So simply providing notice, though, doesn't require legal training or the professional judgment of a lawyer. The statute specifically is talking about participating in the capacity of an attorney, but simply providing notice is really part of the bonding entity's job as an agent of the court. The local rules refer to the bonding entity as an agent of the court. This is simply a way that the bonding agent can move the process along. There is no requirement under the local rule that anything is provided other than, as an entity, we wish to write a bond of $100,000 or more. That's it. That doesn't take legal training. It doesn't take professional judgment. It doesn't go into advocacy or anything along those lines. But furthermore, the statute also provides participate in the capacity of an attorney at a trial or hearing. But nothing in the local rule contemplates a bonding agent participating at a trial or hearing in any capacity.
And does that conclude a suspension hearing where the company is on the line?
What we're saying here is that Rule 12.2 is particularly talking about notice before any hearing would take place. And so it's kind of a precursor to...
Well, how about
if
a hearing is taking place? Does the rule apply also to the suspension hearing? I mean, how is the state or the bonding company supposed to get their evidence before the court if the agent isn't called to testify or the DA is called to testify?
Yes, Your Honor. I think that is a separate issue. Kind of the narrow issue that we are looking at here is particular to the fact that the relevant language that is kind of at play in this case is the bonding entity desiring to write a bond shall provide notice to the court of just about writing the bond in the first place. And so we're not even kind of, I guess, to that part of the process yet.
Will you get there in your argument? Because at the end of the day, this was about the hearing that suspended this company, correct? I mean,
yes.
That's what this appeal is. So at that hearing, how is the court supposed to receive the evidence if the DA isn't allowed to testify about what happened or the bonding agent isn't allowed to testify?
We will, I guess, Your Honor, we will get to that a little bit later. This is more just kind of about generally, is there conflict between the statute and the local rule? And so I think kind of at the end of the day, the situation we have here is very similar to Cumberland bonding, where you had the Tennessee Supreme Court case where you had a local rule, you had a statute. The subject matter of the local rule was simply not addressed by the statute. And I think that's exactly the situation that we have here. And if we have no conflict, then we have no violation, if that makes sense, just in kind of looking at the local rule and the statute. But I do actually now kind of want to get to a bit more of the arguments that my friend raised, kind of dealing with the hearing itself and what the trial court found. And so kind of the next argument was that the trial court erred by finding that notification was not given by a waiver, that there was that the trial court improperly relied on simply the opening statement, that there wasn't other evidence in the record. And I do actually want to take a step back here at this point and discuss how under the local rule 12.2, there are really kind of two ways that the local rule can be violated in the notice context. The first we can see kind of by looking at the language that we were talking about a moment ago, and that is if a bonding entity desires to write a bond of $100,000 or more, the bonding agent shall provide notice to the court and the district attorney general, whereupon a hearing will be set. And so if a bonding agent fails to provide notice to the court and fails to provide notice to the district attorney general, that is a violation of Rule 12.2. But there's another way that this rule can be violated as well that is implicated in this case, and that is that the default is if there is going to be a bond, a bail amount of $100,000 or more, the default is that there will be a source hearing. The district attorney general and the district attorney general alone has the authority to waive that source hearing. The relevant language from the rule says that the district attorney general may waive such a hearing upon notice to the court. So if a bonding agent goes ahead and writes a bond before the district attorney general provides notice to the court that a hearing has been waived, that is a separate violation of, an independent violation of Rule 12.2. And at this point, I do want to point out an error in the state's brief. The state seems to indicate in its brief that the trial court found both of those errors occurred here, both that the bonding agent failed to provide proper notice to the court and the district attorney general, and that the bonding agent went ahead and wrote the bond for over $100,000 without receiving notice of the waiver of the source hearing from the district attorney general. But what the trial court actually found was, although there was adequate notice found to the court, provided to the court and the district attorney general, it didn't matter. Rule 12.2 was still violated because the bonding agent went ahead and wrote the bond without hearing that the source hearing was going to be waived or not. Now, it's the state's position that adequate notice was not provided to the district attorney general in this case, but this court doesn't even need to address that issue because of the separate and independent way that the trial court found Rule 12.2 was violated. And there's plenty of evidence in the record to support this. For example, in my friend's own briefing before the trial court, this is volume 1, page 36, Miss Nicholson informed him that Hans had not responded. Miss Nicholson is the court clerk, informed him, the bonding agent, that Hans, the DA, had not responded. And yet, he then went ahead, the bonding agent went ahead and wrote the bond anyway. This is an admission by my friend that goes into this very point. And then furthermore, after the $392,000 bond was written, the DA reached out to the bonding agent, and the agent admitted this. This is volume 2, pages 12 and 14. He admitted he received a text message that said, are you bonding Jessica Thomason? She requires a source hearing. And this was before Jessica Thomason had been released. That was stating the intent of the DA. There was no waiver here, and any additional evidence, even if the DA had been called to testify, it would not have changed the facts that we have here, that the bonding agent himself testified he did not receive any kind of waiver one way or the other, and yet he went ahead and wrote this bond. And as far as the evidence that the trial court looked at, in volume 1, page 38, the trial court stated that he looked at the testimony of Mr. Carroll, he looked at the exhibits that were tendered, he looked at the argument or the arguments of counsel and the entire record in reaching this conclusion. So we see that the trial court did not err in finding that Local Rule 12.2 had been violated. The next argument is that the trial court erred by requiring Tennessee Bonding Company to wait until it had an order from the trial court before issuing bonds of $100,000 or more. And the kind of main thrust of this argument seems to be a kind of usurpation of jurisdiction argument, that essentially the trial court was usurping authority from the General Sessions Court. But there was simply no usurpation going on here. The limitation was on Tennessee Bonding Company, not the General Sessions Court. Both before and after this order was put in place, the General Sessions Court was free to set bond amounts as high or as low as it wanted to. It's just that Tennessee Bonding itself must get approval before writing such a bond. But even if, kind of touching on your questions from earlier, Judge Easter, even if there was a usurpation of jurisdiction going on here, the case law in this area is very clear about the broad and wide discretion that trial courts have in this area. We cited the cases in our brief from this court, from the Tennessee Supreme Court, affirming a trial court's suspension of bonding companies from writing any bonds in entire districts or entire county-wide, basically any court in a jurisdiction, or a district rather, or a county, for violating local rules. And that's exactly what we have here. As this court has held, a trial court is given wide discretion in its regulation of bail bondsmen, and its actions will not be overturned absent of showing they were arbitrary, capricious, or illegal. Or again, it is within the inherent power of the trial court to administer their affairs, including the right to impose reasonable regulations regarding bail bonds. And we can see from taking a quick look at relevant portions of the local rule that this order fits comfortably within it. Rule 1 states that the circuit judge of Hickman, Lewis, and Perry County has the authority to promulgate rules and requirements and regulate bail bonding entities within those counties. And Rule 11 provides that the court may impose limits and conditions necessary to ensure the professional standing and reliability of the bonding entity. And so we have a situation here where a bonding entity violated a local rule, and this portion of the order was directly responsive to that violation in a way to regulate the bail bonding entity and to ensure its professional standing and reliability moving forward. The final two arguments I will address together briefly: that the DA should have recused himself and his office, and that the trial court erred by allowing the state to call bonding agent without notice to the surety. Both of these arguments were waived because they were not raised below by oral motion or written motion. We argued this in our brief. There was no response because, in the sense that there was no reply brief filed to that. And simply discretionary review is simply not appropriate here, as this court and the Tennessee Supreme Court has repeatedly held. Where there's no specific allegation of plain error that's been raised or arguments addressing the factors permitting its application, plain error review is simply not appropriate. And that makes sense, because it is my friend's burden to establish every element of plain error, and if that is simply not raised, then plain error review is not appropriate. And so for all of these reasons, the state would ask this court to affirm. Thank you.
All right, thank you, General.
Just want to touch briefly on a couple of things that the state said. The state said that there were no conflict between this statute and the local rule, and that notice requires no legal training. What happens when the district attorney tells the bonding agent, no, you're going to require a source hearing? What did they tell the defendant at that point? What their legal avenues are? That is legal advice. Yes, the notice is not necessarily illegal, you need legal training for that, but what happens when the defendant asks them, hey, what happens now? I'm asking you to get me out of jail. Why can't I get out? I can't tell you. I can't tell you at all.
But it's not the bonding company's job to get the accused out of jail.
It is when they come to them for a service, and that is their sole service, is to get them out of jail. And so specifically it says that bonding entity should give notice to the district attorney. That is where we specifically have conflict. To the court, we have no problem. We followed that to the letter. Mr. Carroll even testified, I talked to Dana Nicholson. She is the head clerk. She would then go to the district attorney and say, hey, Tennessee Bonding is wanting to bond this person out. Do you have a conflict with that? And in the record, in this particular case, that is exactly what happened. Mr. Carroll waited for hours in the clerk's office waiting for permission. She said, hey, I haven't heard back, go to lunch, come back. He came back. She said, hey, go ahead and write the bond. Now, the time is a little different than what the state is saying, because Mr. Carroll testified, I made the bond with permission from the court, and then I had a dental procedure later. He texted after I'd already made the bond about it. I didn't respond because he was under anesthesia at that time, but the bond had already been made, and he had been told by the court that to go ahead and make the bond. And that is where it's getting difficult in this circumstance where, hey, the court is saying go ahead and make the bond, but the DA was saying I never gave permission. But we never got to get that testimony.
So we're clear here. When you're saying the court, you're saying that really means the circuit court clerk.
Yes, Your Honor. And that was the accepted procedure throughout the year and a half that this district has been in effect, essentially, because it's split from Williamson County. Mm-hmm. And so that has been the accepted procedure by all the bonding companies, because bonding agents and bonding companies were wary of the legal training, the advice for, defendants, and acting as an attorney, because that's specifically prohibited. And so that is how it would do. And Ms. Nicholson would be the one to contact the district attorney. Now, with regard to the general sessions courts, I agree. The court can set whatever bonds in whatever amount they want, but apparently under this rule, they can't approve who makes the bond. So then would it be the general sessions court judge makes the bond, and then a trial court judge comes in a month later to see who would be able to make the bond? We believe that that is incorrect here. And with regard to the oral motions on district attorney recusal, it's in the record where I objected in opening that said, if he is going to be testifying, making statements, I should be allowed to call him, or he needs to recuse himself. So I would argue that that has not been waived because there was an oral motion in the record.
How does it have anything to do with who makes the bond? Doesn't it have to do with the defendant being able to show where they get the money to pay the bondsman?
But how can they contact the district attorney when they're in custody?
Well, I assume they may have counsel.
But, Your Honor, in these small courts, there's only court once a month. And so if, gosh forbid, they're, picked up the day after court, they cannot have court for another 4 weeks because court is only in session once a month and can only be heard on that. So to get an attorney, you have to wait a month. And then that attorney has to then get the proof and submit it to the district attorney. And if there needs to be a hearing, then it's another month after that. And we're looking at 2 months. That's why the accepted procedure has been, we go through the court contacts the district attorney, and we get a yay or a nay. And in this circumstance, Mr. Carroll, through the accepted procedure, relied on Ms. Nicholson's word.
Was the Thomason case a direct presentment, or did it come through General Sessions Court?
I believe it came through general sessions.
When were you appointed? You were appointed in the case?
No, I'm for the bonding company.
I'm sorry.
No, it's okay.
I took your bait.
She never had an attorney
Okay.
from the get-go, and that's a big problem as well for indigent individuals.
What was the trial court's basis for not allowing you to cross-examine the DA, the Attorney General?
The court did not give one. I asked, since, there was no notice given for Mr. Carroll being called by the state, that I, cross-examine district attorney, and his simple answer was no. We're moving on.
So the defendant was indigent.
I do not know.
Well, you just said that.
Well, if she was indigent, she would have to wait, but I do not know her financial status, as I did not represent her. There are no more questions. Thank you, Your Honor.
All right, thank you, counsel. Good argument by both sides. Y'all want to? Good. I'm good. Go for the next one. Next case, please.
State of Tennessee versus Matthew Cole Welch.
Good morning, Your Honors. Mike Flanagan of the Nashville Bar, here on behalf